Appellant has the right to have rebuttal up to a maximum of 5 minutes. So let me know if you would like rebuttal when you come up and introduce yourself. So for the case of Keisha Lynn Hardy versus State of Florida, are we ready, sir?
Yes, sir.
Good morning.
Good morning, Your Honor. Andrew Crawford, I'm here on behalf of Ms. Hardy, and I respectfully ask for 5 minutes of rebuttal.
All right, sir.
Mr. Crawford, can I just get right into it? Do you mind? Because
Sure.
we've all read the case.
Sure.
We know all about it.
That would be very helpful for me.
Yeah, so I thought it'd help you focus and not waste time telling stuff we know, okay?
Yes,
So
sir.
here we have a situation where a car is not parked in a space,
Correct.
lights on, motor running, driver is face down on the front seat, asleep. Right, so far?
She's not exactly face down, but her head is down, and
Oh,
she's sitting in the
okay.
driver's seat. Yes, driver's
So
seat.
the officers come up because they're concerned for safety. It's like 4 in the morning, isn't it?
No, sir, it's about midnight.
Okay, dark. After midnight, everything's 4 in the morning to me. But, so it's dark and, so they're concerned and they walk up. And the windows are down, except for the rear windows partially down, but the windows are down, so they don't have to ask her to roll her window down or to get out of the car. And they basically engage her while they don't smell an odor, they don't hear slurred speech, they don't see bloodshot eyes. She's giving cryptic one-word answers and hesitating and seems a little confused. Isn't that enough?
Judge Morris, I submit to the court that it's not enough in this particular case. I know you're familiar with the Dermino case, having written it. However, that case is significantly distinguishable from this case. Officers arrive, they have a concern articulated that there was possibly a medical episode or a DUI. The question really becomes whether the community caretaking exception to the warrant requirement exists here. I would submit to the court that based on what the officers observed on that video, they approach her, 2 officers approach her. You see one officer initially in the body cam, which was submitted into evidence. There's a second officer that goes behind the car to the rear passenger side, asks Ms. Hardy to roll down her window. Additionally, the officer asked her to open her passenger side door. The
Did
question.
the seizure occur there?
The seizure occurred when both officers are shining flashlights into the car. There was no,
Let me just
sure,
because I want to try to understand it.
understood.
Officers are shining flashlights in the car because they've come across someone who they think may be in distress. That's a seizure because they're checking that out?
Under the case law that I've cited in the initial brief, yes, I would submit that it is. Especially when you have 2 uniformed officers, both shining flashlights into the interior vehicle. The seizure occurs there. If the court does not find the seizure occurred there, then the seizure absolutely occurs when the deputy asks to roll down the back window.
Well, isn't she in actual physical control of a vehicle that's running?
Correct.
Okay, so objectively, you approach the vehicle, it's running. She gets startled by them knocking on the window or saying something to her, puts it in drive and just pulls right out.
That's not what happened in this case.
It could. So you flash a light in there to see what's going on. What's interesting in the case is the officer testifies, then we see the video and the audio, and it corroborates his concern. She was out of it. She was confused. She kept putting the key in and out of the ignition. The windshield wipers would go to and fro. Well, I've had that happen to me too, so that's really not a key. But it's still indicia of, do we let her go? Do we just let her go right here and there when she's confused? She's in actual physical control of the vehicle. She was slumped over. The vehicle was pointing in the direction of the road. Do you let her go then? And she gets into an accident
Well,
and they get sued?
Judge Sleet, there's a lot to that. The first one is, if that was the case where a person is behind the wheel in actual physical control and they're asleep behind the wheel, that would mean just because they could drive, officers are entitled to stop them, and that's not what the case law from this weren't
the officers entitled to resolve under the community caretaking doctrine, entitled to resolve some ambiguities in favor of detention?
Certainly, Judge LaBrette. However, in this particular case, and what I've argued in the initial and reply briefs, is that the officers exceeded the scope of the community caretaking doctrine. And if you, throughout the video, there's one point especially, which is about 7 minutes, 6 minutes and 55 seconds in, where the officers don't know what they have. In fact, one officer comes over to the other officer and says, "What other DUI indicators do you
Did
have?"
the field training officer testify, or is the only way we have that information from the video?
You have it from the video, but
Not testifying.
not testifying, but the video was nevertheless admitted into evidence.
Understood, I just wanted to clarify that.
Yes, and 6 minutes and 55 seconds in, one officer asked the other officer on the body cam video, specifically, "What other DUI indicators do you have here besides she was sleeping?" There was no odor of alcohol, they both specifically state. At one point during the video, they asked if there was any unsteady gaits, bloodshot water guys, things of that nature. They didn't observe any of that. So once they ascertained, they also mentioned the blood pressure medication multiple times in the video, which she specifically said that she was on. Once they have made a determination that there is some type of medical episode, and whether that's dissipated or not, which they at some point during the video concluded that it did, you actually have the officer who stopped Ms. Hardy get on his phone with his supervisor. He dials his phone with his supervisor on the video and specifically says, "I'm not sure what we've got here. It could be blood pressure. It could be a DUI. I don't really know." And if you look at the community caretaking doctrine, it's got to be solely based on concern for a medical episode or concern for some type of public safety issue. Not,
So this is a Danielowitz case?
yes, sir.
Just like it. I mean, as close as nothing's ever just like it. I know.
As close as you can possibly get to Danielowitz, yes, this is a Danielowitz case from this court issued in 19.
So her behavior could be either interpreted as innocent or something else, and that's not enough.
That's not enough. And once their suspicions regarding the medical episode are dissipated, then it exceeds the scope of the stop, which
Well,
has
but
happened here.
is it really dissipated? Because it would seem to me, from the trial judge's perspective, and I commend the police officers for having video, because it's good for defense attorneys like you, getting the context, because you can clearly see that these officers are not sure what they have. Their phone calls are on video, we can hear the audio, but I think you would admit, they weren't certain what was wrong with her. They just weren't. So at that moment, it's reasonable to say that you should not let it go, because she get in the car and drive away. They weren't certain what was wrong. I mean, that's clearly from here.
Well, and Judge Slade, in order to stop somebody, in order to detain them, you either have to have reasonable suspicion of criminal activity, or in a case involving a motor vehicle, probable cause of a traffic violation.
Well, I know all that, but
You
are you
do.
sitting here telling me that the officers didn't have a right to walk up to this running car with a passed out driver in the driver's seat?
That's not at all.
Well, that's where we start.
That's where we start, but that's not
Okay,
what I'm
so
arguing.
they also have the authority and the responsibility to determine if that person dead, incapacitated, impaired, right?
Officers under the community caretaking.
Is that right or not?
It depends on the totality of the circumstances,
Well, I'm looking at
yes.
the totality of the circumstances, because the car is parked in a business that's closed, it's angled toward the road, she is easily capable of awakening and driving off.
Can I ask the question in a different way, because it's a good question? So let me ask you this, you were a
It's probably not
prosecutor, you've
that
been a
good.
defense attorney for a long time, you've been on both sides of this fence. At what point can you fairly say that the facts developed such that there was reasonable suspicion? Can you draw that precise line?
In this, there's no concrete answer to these type of questions. As the court knows, they're very factually driven. based on the totality of the circumstances. To go back to Judge Sleep's point, though, just because a car is running and just because someone is in the driver's seat, courts of this state have held that that's not enough to initiate a stop. We have that in the Danielowitz case, we have that in the De Lorenzo case, we have that in the Gentiles case.
But I understand that too, fully. And I did that as a circuit judge, but my question goes beyond that. They're trying to find out what's wrong with her. That is not a stop, according to the case law. They have a responsibility, community caretaking responsibility, to find out what is going on with this person for their own benefit, correct?
I acknowledge that the community
Okay.
caretaking doctrine, yes, sir.
All right, so they went about that. At what point are you saying that it was a seizure?
I'm saying seizure when they ask her to, when they initially go up and they shine the lights into the vehicle, both of them, they ask her to exit the vehicle, they ask her to roll down the window, they open up the passenger door. When they say that, when she asked if, the officer in fact asked if he can open up the passenger door, and she says no. Those are seizures of those particular.
Well, rolling the window down typically in the case law would be, but this is a case where the car had all the windows down and the back window was half down.
Correct.
Doesn't that make a difference?
Under the case law, no, there's not that distinguishment. And in fact, that was one of the things that Your Honor referenced in the Dermio case that you wrote in 2013. That was one of the issues. But that case was very distinguishable from this case. And Dermio was also in Manatee County, and it was at a closed bar at 3:30 in the morning, where the person there was completely unresponsive. And there was also a strong odor of alcohol or a strong odor of marijuana once the door was open, which we don't have any of that.
If you I'm sorry, let me interrupt something. Part of what the fruit of the seizure was a bunch of prescription drugs too, right?
Correct.
Those don't emanate an odor, so I'm gonna take a bunch of Xanax and be sleeping in my car, and I'm impaired, with honking the horn, leaving the windshield lights on, and keep putting the key in the ignition. I'm not sure that I buy into the significance of no odor of alcohol in these circumstances under the community caretaking doctrine.
I understand, Judge LaBrette. The community caretaking doctrine says that the officers have to be solely concerned with safety, and the scope of the community caretaking doctrine, which is a judicially created doctrine, cannot exceed that and cannot be used as a, say, pretext or other way to gain evidence of a criminal
That
charge.
takes me back to my original question of you. The trial judge certainly, in her recitation of the facts, I think outlined a bunch of, from your perspective, what could be fairly characterized as ambiguities in the
Correct.
situation. Alcohol, but not really fully coherent. I'm struggling with, under the doctrine, as Judge Sleet asked you a few minutes ago, these officers were supposed to just walk away and let her drive out of that parking lot at 2 o'clock in the morning when they don't know what's going on and she's not really there.
I'm not at all saying, and I'm not arguing to this court, that the officer should have just let her drive her away. What I'm saying is a limited seizure under the community caretaking doctrine was essentially became illegal once they started to, when she told the officer specifically that she was okay. When the officers did not note any type of indicators that she was under the influence of alcohol or any type of other controlled substance. What's key is watching the video as a whole and listen to what the officers say in their interaction. At first, the officers initially thought that it was a medical episode. They speak to I presume, a DUI officer or sergeant or lieutenant and looking at the case itself. They say they don't know what they have here. They are all treating it initially as a medical episode. Then at some point, they run her previous driving history, find out that she's been suspended. Then all of a sudden now it turns into a DUI investigation. Much before then, though, I would submit to the court that they exceeded the scope of the community caretaking doctrine in this particular case. are they entitled to say, okay, you can't drive off and ensure, protection to the public? Sure. Was she actually about to drive into the street? No. Was her car obstructing any traffic? No. Was there any traffic violations? No. She was in a parking lot, and if you look at the video, it's a closed parking lot, kind of behind one. It's not like access initially onto a busy street. So that concern did not exist here. The question becomes, when did the scope of the seizure exceed what is allowed under the community caretaking doctrine? And that's what took place here. After they get her out of the car, they don't notice any signs of impairment. They think that it's probably a blood pressure issue at this point.
You're into your 5 minutes. You can use it the way you wish.
I'd reserve the balance.
All right, sir. Thank you.
Good morning, Your Honors. Excuse me. May it please the court. My name is Laura Dempsey, and I'm from the Attorney General's office here on behalf of the state of Florida, the appellee in this case.
Do you mind if I just get into it again? Because the question I had for you, and I'm kind of interested in this, this was a very prolonged stop, wasn't it?
Yeah.
It went all night, didn't it?
It's open to interpretation depending on what you categorize as all night.
Yeah.
Go ahead.
I mean, it seems to me they were still fiddling around with this at 5 and 6 in the morning, weren't they?
They were extensively debating back and forth whether this was a medical incident or a DUI of some nature, like what Judge
So
Martin.
I guess my question is, if they initially approached them, the caretaker doctor, they were concerned about their well-being.
Yes.
They spent a long time trying to figure that out.
Agreed.
I mean, isn't that sort of intrusive all by itself? Shouldn't they just kind of got in, figured out what was going on, got out, and if nothing was there, leave her alone?
And I think in certain circumstances, if answers had developed to their questions, that's exactly what would have happened. However, in this case, as they show on the video, they spent time with her and no questions were being answered. Her demeanor, her well-being, her alertness wasn't improving. She didn't exhibit any indication. She wasn't helping them figure out what was going on. She was being, not meaningfully
She didn't have
communicating.
any odor, she didn't have any slurred speech, she didn't have any bloodshot, watery eyes. She was answering their questions, but in a very cryptic way, with one answer, one-word answers, right? I mean,
She was answering some questions. The questions she never answered was what's going on. And they asked her that about, I don't want to put a number on it, but repeatedly.
at some point, isn't it right to say to the police, leave me alone, it's none of your business?
She didn't say that either, though, Your Honor.
But wasn't that the result of her affect?
That's not how I would interpret her affect.
But-
I don't think
but you're
that's
a
how,
prosecutor.
I don't think that's how a reasonable officer would interpret her affect. That's not how these officers interpreted her affect. That's not how the trial judge interpreted her affect. So it's the lack of any meaningful communication here that highly distinguishes it. The officers observed her for a long period of
How
time.
long should a police officer be able to detain somebody without reasonable suspicion, trying to figure out if they can find reasonable suspicion? At some point, doesn't that become onerous and intrusive and violates the Fourth Amendment, just un-American?
Yes, at some point, if their concerns for her safety are dispelled and they have no reasonable suspicion and they continue to hound her until they do, that's absolutely a violation of the Fourth Amendment.
Well, after she says high blood pressure, why are they still inquiring about medical? There's millions of people with high blood pressure. But they kept going.
Yes, because her behavior did not align with the answers she was giving.
She knew she was in Palmetto.
Yes.
Okay, so she knew where she was.
She also put her keys down and then reached for her ignition as if she still had the keys in her hand, and then didn't, and then reached back down for them again to put them in the car.
But I don't think that was enough for the police. They were still, even after that, they were continuing to try to,
If that was enough, I would have thought they would have ordered her out of the car and started their DUI investigation. So apparently that didn't trigger anything with them.
Well, what it triggered is she's not well. They don't know why, but
But they never called ambulance or paramedics or anything. They didn't make any effort to do that. So if they were concerned about that, you know, and they didn't see any of the indicia of being the influence, why'd they call an ambulance?
Throughout their investigation, the more the indicators she gave, the more it pointed to a DUI rather than medical.
See, what it looks like is they knew they didn't have enough, and they were gonna mess with her until they got enough. That's what it looks like.
The underpinning of the Fourth Amendment is reasonableness. Was it reasonable for the officers to continue investigating under these circumstances to inquire whether she's okay, needs medical attention, or a DUI is occurring, or just she becomes alert, you know, she was just sleepy and she wakes up and then she seems fine again. And then under those circumstances, they don't have anything and they let her go. Under this case, yes, they end up calling traffic unit instead of an ambulance. She's saying over and over doesn't take anything like.
Wouldn't 30 minutes be a long time for them to figure this out? And they fiddled with her for a couple hours.
Well, up until they found out her driver's license was suspended was about 10 minutes or so.
Yeah, but if they're checking for her health, why are they checking her driver's license?
They're checking both. They don't know what's happening. They don't know what's happening.
Well, checking the driver's license isn't going to confirm or deny any health issues.
No, and she's denying all health issues, Your Honor. So it could confirm or deny reasonable suspicion. And I think they had, based on her behavior, they had reasonable suspicion to be asking her out of the car as well. Yes, yes, the medical question was an option for what was wrong with her, but so was a DUI, and they're not required to ignore their common sense, ignore their observations while they're conducting a welfare check in order to have it be a medical question only. And there's no bright line for, okay, this must end in order for then all reasonable suspicion has to be built after that.
Well, I mean, the Daniels case has a proposition: once a law enforcement officer is concerned with the welfare of the person has been satisfied,
Yes.
continued detention is not permissible. So where in this exchange and this dialogue is law enforcement satisfied it's not a health condition, but it's a crime?
The officer testified at the hearing that his concerns for her well-being were never dispelled. The body cam video.
Where's the EMS?
Huh?
Why not EMS?
Agreed. The body cam video, again, is only a very small part of what was their totality of their interaction. So we only see that small part. The question before this court is whether it was reasonable for the officers to detain her up until they found out that driver's license was suspended. And so, yes, if the result had been, if it had turned out to be a purely medical incident, we would want the officers to have pulled her out of the vehicle, see if she's okay, and if it had been the appropriate conclusion, ultimately call EMS. That doesn't make the stop and the detaining her and the asking her to exit the vehicle unreasonable under these circumstances. And the chief difference between this case and much of the case law relied on by the appellant is the time they do put in observing, asking her questions, seeing if she's okay. And again, her lack of responsiveness, she does not take the opportunity to dispel any of their concerns about her well-being. And that's a big difference between this case and many of the others. The one off the top of my head where the guy has the knife he's sleeping with the knife next to him, they don't wake him up and ask him a bunch of nice questions and ask him if he's okay. They rip him out of the car immediately.
See, here's what's concerning me about the facts of this case. If the officers had shown up and she exercised her Fifth Amendment right to remain silent, say nothing, they would have been there for 5 days waiting for her to do something. They would have. This is what this demonstrates. They hung around for hours waiting for her to do something that they could, make a claim with. And a lot of defendants are smart enough to say, I exercise my right to remain silent, I'm not saying a word. So what's a police officer do then?
Your Honor, in that case, or in that circumstance, I think they would, in my interpretation, is very different than this circumstance, because that means they're meaningfully communicating with the officer, they're actively exercising their right, and they're informing the officer of something,
Did she voluntarily provide her driver's license?
No, Your Honor. They ran, I believe.
So the police officer was going to hold it against her if she would exercise her right to remain silent? Did I understand you to say that?
Sorry, repeat what you said, I'm sorry.
Okay. Yeah, it concerns me, again, the length of time this went on, they had nothing, and they kept hanging around. Shouldn't they get in and get out? I mean, don't the American people deserve not to have police officers circling them, waiting for them to do something? If within a reasonable period of time, police officers don't see anything, shouldn't they move on, go find something else to do?
I'm gonna push back on Your Honor's description of them not having anything, and that's why they kept hounding her. They had extremely odd behavior that she was exhibiting. I think pretty plainly she was not clearly communicating. She beeped her horn, she's messing with the keys, she's doing odd things, she's described as sluggish, mechanical, confused.
Accidentally beeping your horn and fiddling with your keys, geez, I could be arrested any given day then. I mean, have you never accidentally bumped your horn before or fiddled with your keys? I mean, that's not like a smoking gun or anything.
In this case, and again, my description, I think you honors have viewed the video. I would obviously rely on that. I think words describing her behavior does not fully encapsulate the oddness of the behavior, the weird circumstances. They also need to take into consideration the odd circumstances in which they approach the vehicle, that's in a closed business at the wee hours of the morning with the lights on, she's not in a parking spot. So you take the totality of those circumstances with the totality of the odd circumstances. Yes, singularly messing with your keys or honking your horn alone is not enough. Being parked in in a closed business with your car on, sleeping in the driver's seat is not enough on its own. But it's the totality of all of those things together that makes it reasonable. And at the point where she's messing with her keys a bunch, she's making the officers nervous, presumably about the driving off or she doesn't seem okay, and she's messing with her keys at the same time she's not responding or communicating with officers at all. So under those circumstances, detaining her under the community caretaking doctrine was reasonable here. And if Your Honors have no further questions, I'll rely on the merits of my brief.
I can't think of any more.
Thank you. All right, Mr. Crawford, you have 5 minutes, sir.
Thank you. The community caretaking doctrine was initially mentioned by the United States Supreme Court in Caddy versus Dombrowski, which in 1973, in which they specifically held that this doctrine, community caretaking functions must be totally devoid from the detection, investigation, or acquisition of evidence relating to a violation of the criminal law. In terms of the scope, the Brumlow case, which actually the state cites in their brief, goes on to say the scope of an encounter associated with a welfare check is limited to prevent the exception from becoming an investigative tool that circumvents the Fourth Amendment. Without any reasonable suspicion that criminal activity is or was afoot, the welfare check should end when the need for it ends. And Judge Morris, you hit the nail right on the head. When you're looking at the length of time this took, it's similar to the case law where you have a dog, someone is stopped on the side of the road, a dog comes up, doesn't smell anything, or I take that back, a deputy suspects there may be something in the car, and then they have to wait for 25, 30 minutes for a dog to show before the dog alerts on the side of the car. It's a similar situation to this. The touchstone is reasonableness. And was it reasonable for these officers to hold Ms. Hardy for this extended period of time while they determined whether it was a medical issue or a criminal issue? So not only does it violate the scope, but it also violates the purpose of the community caretaking doctrine when she's being held by the deputies. One of the deputies comes up 7 minutes into the video and says, what other DUI indicators do we have here? It's not medical. They're looking at criminal activity, which is totally devoid of and separate from what the community caretaking doctrine is meant to provide here. The one officer says specifically on the body cam footage, other than her being asleep, what else do we have here? Do we need to still investigate? That was the question. The officer says, yeah, I think we do. Then he calls the supervisor while she's waiting there, detained. That exceeds the scope and the purpose of the community caretaking doctrine.
So I guess the problem I have with this case is I don't understand why they didn't call the paramedics within 30 minutes. They obviously had something, but not enough for reasonable suspicion, but also too much to just walk away from her. They should have called the paramedics. I still don't understand why they didn't do that.
They didn't, which goes to the community caretaking doctrine itself. Were they actually concerned about her medical situation, or were they more concerned with gathering criminal activity? If they were concerned with her medical situation, they would have called EMS. They would have had somebody there. They didn't do that. What they did is they detained her for an extended period of time, not sure what it was, not sure whether it was medical, holding her under the guise of the community caretaking doctrine, when in fact, they got her driving history back after being detained for a substantial period of time and say, oh, she's got a previous suspension. This must be a DUI, which they refer to as a signal 1 on the video.
Yeah, 1 minute, sir.
Yes, sir. Based on the community caretaking doctrine not applying, based on the extensive and length of time that Ms. Hardy was being held, I respectfully ask this court to reverse the remand for discharge.
Thank you very much. Very well argued. There's a lot to think about.
Should have had a class from Stetson Law School watch this. This was excellent. You both did a great job.
Thank you.
Both of you two. Our second case, Kyle McClama versus Mark Glass, Commissioner.